Okay, so again, thank you everybody for joining Fieldstone4U. These events come to us sometimes very planned and sometimes very organically. This happened to be more of the organic nature in that Lauren Brand, who is one of our network members, Lauren was in a learning group and she's one of our Creative Encounters facilitators, and she's also one of our executive coaches. She has brought Ron, her husband, to a couple of Fieldstone4Us before, so we have met him, and she told us that he's an employment attorney and that he had offered his services to the nonprofits that we serve. So I said, well, let's just have him jump on a call and tell us exactly what he would like to do and how he could work with us, and we can use this opportunity to ask questions. So that's how this one came about. And again, I'm just grateful that you actually respond and listen to Robin Stropko's email. So Robin, good job getting the word out. And thank you to all of you again, just for joining the call. Just some housekeeping. I just ask that you mute your audio so that there aren't any distractions. And then if, when it comes time to questions and answers, just raise your hand and then everybody knows that you're going to talk. So then you can just unmute yourself. Otherwise, as you know, with Zoom by now, we're all getting pretty good at it, that when you talk, it closes everybody else out and shuts them down. So we want to make sure that Ron has the floor. I see somebody is chatting. Let's make sure there's nothing that I need to be aware of right now. Should we? Yes. So what I'd like for you to do very quickly is just, if you would go, actually, I'll call on you because my screen, it'll make it so I can kind of direct it. Let everybody know, to Ron, who you are. So your name, your organization, and your role of the organization. So Ron has an idea of the people in the room. So Mark, why don't you start?
Good afternoon, everyone. Nice to see many of you again here on this Fieldstone4U. My name is Mark Lee, CEO at WTLC. We are a domestic violence and human trafficking service provider.
Thank you. Renetta?
Hello, I'm Renetta Johnson with Waymakers. I am the executive director, and we work with at-risk youth and provide primary crime victim services.
Thank you. Pam?
Hi, I'm Pam Estes, and I am the CEO for Boys and Girls Club of Laguna Beach and Lake Forest area. But we're reaching beyond that right now with virtual.
I think we're having some technical difficulty, but I think we got an idea. Christy?
Hi, I'm Christy Perez. I'm the executive director of Inspire, and we have homes and mentoring program for aged out foster and homeless youth.
Thank you. Lauren?
Hi, everyone. I'm Lauren Brand. There's a little bit of an echo because Ron and I are in different rooms. But I'm the director of operations for Mind OC, which is an organization that is doing a transformative change for the mental health system in Orange County.
Okay. Dawn?
Good afternoon, everyone. My name is Don Han. I'm the operation manager for OC Human Relations, with a human relation organization in Orange County. They do dispute resolutions, responding to hate crimes and community buildings in Orange County.
Okay, and Allison Stanley is on the call. She doesn't have a microphone, but she's with Project Access, and she's the HR manager, and they serve 20,000 individuals living in low-income apartment communities in 13 states. So welcome, Allison. And Dawn? Dawn Reese? You here? All right, Dawn Reese is the CEO with the Wooden Floor. And Patricia? Patricia Gonzalez is with the Delhi Center. Adolfo Juarez also does not have a microphone, and he is Associate Director of Finance and Human Resources with Friendship Shelter, right, Adolfo? I'm drawing a blank. I believe so. Yes, Friendship Shelter. Good job. Patricia also does not have a microphone. So as I said, she's with Delhi Center. And Stephanie?
Hi, everybody. I'm Stephanie Bobadilla. I'm the Chief Education Officer for the Muckenthaler Cultural Center.
Excellent. Okay, thank you, everybody. So at this point, I'm going to turn it over to Ron. Ron, if you would introduce yourself and tell us a little bit about yourself and your practice, and then it's all yours. And we have until 2 o'clock, but if people want to stay on, I don't want to take advantage of Ron's generosity, but the plan is to end at 2, but if we are in the middle of something, it's totally up to you to stay. Robin and I have nowhere else to go. So again, Ron, thank you so much for offering to do this for us. So thank you. And here you go.
Oh, my pleasure. Thank you for having me. So my name is Ron Brand. I'm a partner at a firm called Kahana & Feld, and I am a labor and employment attorney, and I represent businesses, for-profit and nonprofit, in their labor and employment law matters. So I've been doing it for about 20 years. So for today, I really want to give you an opportunity to ask any questions you have regarding the issues and concerns you need to look at when reopening. Right now, the state of California shelter-in-place order is still in place. So technically only essential businesses can operate. And I don't know when the California state order will be rescinded, but I suspect it'll be loosened over the next few weeks and rescinded at some time in the future. But as jurisdictions, as counties and the states start loosening restrictions and reopening businesses, there are some things from a labor and employment perspective that you need to be concerned about. So I'll just briefly go through them, and then I want to open up to questions because I suspect you have a lot of questions about what you should be doing. But there are basically kind of 3 buckets I want to talk about. One is, what are the things you need to prepare for from an HR personnel perspective, and what things you have to be concerned about from that perspective? So that's one bucket. The second bucket is, what type of labor and employment cases can we expect to see because of the pandemic? Labor and employment law lawsuits from employees or former employees. And then the third bucket is, what can you do now to try to prevent as much as possible any liability for those cases that I see in the pipeline? With respect to the first bucket of the HR personnel issues you need to be concerned about, there are 10 key issues, okay? One is workplace safety. There's what's called the General Duty Clause of the Occupational Safety and Health Act. And basically it says that employers have to maintain a safe and healthy work environment for its employees. And also under California law, employers have an obligation to maintain a safe and healthy workplace. And so what does that mean with respect to COVID-19? Well, there are a variety of things. It means complying with OSHA and Cal-OSHA, that's the California version of OSHA, Cal-OSHA's recommendations and the CDC guidelines. The CDC has issued various guidelines on what employers need to consider when reopening the workplace. And they list a whole different things that employers should do to maintain a health and safety work environment. Some of those things include implementing employee health screening. You're allowed to take the temperature of workers to see if they have a fever. You're also allowed to test workers. Now, the chance of you getting a hold of a COVID-19 test is probably slim to none, but if you are able to get a hold of a COVID-19 test, you can test employees who are returning to work. So those are some of the things you can do to try to maintain a health and safe workplace. Another thing is to provide what's called PPE, personal protective equipment. So masks and gloves, face shields, personal hand sanitizers, bleach, wipes that have bleach in it. Those are the types of things that you can provide to your employees. You also want to establish cleaning procedures, disinfecting procedures. I recommend that you have an office cleaned, almost every day if you can, once you reopen, because studies have shown that the COVID-19 virus can stay on different surfaces for either a few hours up to several days, depending on what type of surface it is. But COVID-19 can stay on plastic and metal for several days likely. So you want to make sure that you clean and disinfect. You want to establish physical social distancing measures. To the extent possible, have people stay 6 feet apart. Maybe you stagger shifts and lunch and rest breaks so that fewer people are together in groups as much as possible. Maybe you rotate weeks in the office and working remotely. Move workstations to increase the separation. You want to restrict business travel to only essential travel. So there are a whole wide range of things you can do to make the workplace healthy and safe as possible. Another issue you need to be concerned about is the recall procedures. Who are you going to call into work first? You want to have a phase-in of employees. So maybe you use seniority or other type of non-discriminatory factor to select who will come in and when. You want to decide how you're going to handle employees who are unable to work or maybe are unwilling to return to work. So generally speaking, employees cannot refuse to work simply because they're concerned about potentially getting infected. Now, of course, I'm talking about in a situation where the stay-at-home order has been lifted and you are allowed to have employees come back to the office. I would certainly not force employees to come back to the office now when you have the shelter-in-place order in effect. So I'm talking about a situation that once the restrictions are loosened, the stay-at-home order is lifted, and then employees can start coming back to work. Employees cannot refuse to come to work simply because they're scared of maybe contracting the virus. They can refuse to come to work if there's an imminent threat of danger to their health or safety. And if the order is lifted and people are allowed to come back to work, I wouldn't characterize that as an immediate threat. But just because they have to come back to work doesn't mean necessarily that you should force them to come back to work. Maybe there are situations where teleworking is still feasible, or maybe there are some other types of things you can do so they don't have to come to the office as often as they might need to. So I would take it on a case-by-case basis. If a certain employee refuses to come back to work, and this is again after the stay-at-home order is lifted, you deal with each situation specifically. So I wouldn't have a blanket policy. There are employee benefits that you need to be concerned about, just in terms of group health insurance coverage and flexible spending accounts. There might be changes in those depending upon how many hours an employee ends up working, or if an employee only works a few days a week. So those are some of the employee benefits issues that you need to be concerned about. Compensation issues, primarily wage and hour issues. So if employees have to come to work and they're waiting to get tested and they have to wait in line to get to have their temperature checked, that's typically compensable time. So you're going to have to pay these employees if they have to wait in line 10 or 15 minutes, assuming there are a lot of employees. But if they wait in line, you have to pay them for that time. You also have to pay them for the time that they don and take off personal protective equipment. So there's going to be a whole bunch of new wage and hour issues that are going to come up because employees are going to have to take the time to prepare themselves in order to prevent as much as possible the spread of infection. Remote work. Yeah, does anybody have a question? No? Oh, I thought I heard something. Okay. People may want to continue working from home. You know, now that people have been working from home and been around their families for 6-7 weeks, a lot of people may like to do that. And so the question is it feasible? Can the work be done remotely? So that's another thing you're going to have to consider is people who are now going to be requesting remote work abilities and possibly, or maybe coming into work only a couple days a week and working from home a couple days a week. You just have to be prepared that people are going to maybe ask for those types of accommodations, like working from home. So that's kind of like the HR stuff that you have to be concerned about. I mean, there's a whole lot of other things as well. There's new hire paperwork, and you may want to have to change policies depending upon the changes you make in the workplace. But those are from the HR personnel perspective. Now, let's talk about lawsuits. I believe that there's going to be a avalanche of labor and employment lawsuits. That's what I predict. In fact, there is already one lawsuit pending in Pennsylvania in federal court where an employee sued Eastern Airlines, alleging that the airlines interfered with her rights under the Families First Coronavirus Response Act. And are you familiar with that statute? It provides for emergency paid sick leave and paid family medical leave for just certain situations. So she's alleging, in this case in federal court in Pennsylvania, that the employer interfered with her right to get paid under the FFCRA and she's claiming retaliation as well. So those lawsuits are going to, I think, going to be in the pipeline, basically violations of the FFCRA. You'll probably see a significant increase in workers' compensation claims. Now, there's a question whether contracting COVID-19 is a workplace injury such that it will be covered by workers' comp. That's yet to be decided. I think that the workers' compensation laws will likely be amended to include compensation for people who contract COVID-19 at the workplace. I don't know if that's going to happen for sure, but I think that may happen, which actually may be a good thing for employers because that'll essentially prevent the employees from suing employers in court for personal injury damages. You know, the workers' compensation system was a compromise between workers and employers, basically saying if you get injured on the job, you can go to this workers' compensation system and get compensated a lot more quickly than if you were to sue. And in return, employers know that they can't be sued in court, that any workplace injury will go through the workers' compensation system. So now the question is, can employers be sued outside of the workers' compensation system if they get infected for COVID-19? So that'll depend upon whether COVID-19 is a workplace injury. Oh, I see the cat. Now, if the employers do not take all the safety and health steps that I talked about to keep the workplace health and safe, then potentially employers could sue in court for some type of intentional misconduct outside of the workers' comp system. So that's another reason why you want to take as many reasonable steps as you can to maintain the health and safety of the workplace. Because if you don't take those reasonable measures, there's a chance if an employee gets sick at work that he or she can sue you outside of the workers' comp system. But if you can show that you did everything you humanly could to keep the workplace safe and healthy, there wasn't any type of intent, there wasn't any negligence, then likely that case would have to stay within the workers' comp system. There will likely be an uptake of cases based upon discrimination, harassment, retaliation based upon national origin or ethnicity. You know, there's been an uptick in hate crimes against Asian Americans because some people think that, you know, the virus, because it originated in China, that it's somehow an Asian or a Chinese virus. And so there's been an uptick in hate crimes, and there's been an uptick in employees reporting harassment at work due to their ethnicity or national origin. So I see those types of claims increasing. It was just like after 9/11, where there was an increase in harassment and discrimination claims based on being, you know, coming from the Middle East or being Arab or being Muslim. So I see an increase in those types of claims. I see claims based upon a violation of this general duty clause that I talked about, of the Occupational Safety and Health Act, where employers are not taking the reasonable steps necessary to maintain a health and safe work environment. There could also be invasion of privacy claims. If an employer discloses the name of an employee who is infected with COVID-19, that could be an invasion of privacy. And then I'll also, I think, see wage and hour claims about not being compensated for the time it takes to what's called don and doff, put on and take off the personal protective equipment, or waiting in line to get tested, or waiting in line to have your temperature taken. So I see those wage and hour claims increasing. And plaintiffs' attorneys will definitely take advantage of the situation and try to find every avenue they can to sue employers. Some of those cases will have merit, others won't, but I think that the pandemic is creating the perfect environment for plaintiffs' attorneys to really focus on finding any type of violation that they can that is a result of the pandemic. So the question is, what should you consider doing to minimize COVID-19 related labor and employment litigation and to help defend against such litigation? Well, as I was talking about earlier, make sure you comply with all current guidelines from the leading health authorities, the CDC, the WHO, the state of California, Orange County. Comply as much as you can with those guidelines, and that'll go a long way in helping to minimize labor and employment losses. You want to see if you have insurance. If you have EPLI, Employment Practices Liability Insurance, it can be expensive, but it could be very useful if you get sued. And more of my clients are getting employment practices liability insurance, or it's called also EPLI. So look into getting that. See if it makes sense, if it's affordable. I know as nonprofits, you don't have the same resources as for-profit organizations, so it might not make financial sense, but look into it. Make sure that all the employees have received a copy of your anti-discrimination, anti-retaliation, anti-harassment policies, and make sure those policies are up to date. And you want to make sure that you enforce those policies consistently. I would also consider sending out a written memo to all employees stating that blaming or harassing any ethnic or national origin group due to COVID-19 violates your workplace policies and could be grounds for disciplinary action up to and including termination. So you want to make it very clear that as an organization, you will not tolerate any type of conduct that could be construed as harassing or discriminatory against any ethnic or national origin group. You may also want to consider training your employees regarding what you expect of them, what they can expect of you. Basically just sitting with them and saying, here are all the things we're doing to try to minimize the chance of getting infected with COVID-19. And here's what we expect of you, complying with anti-retaliation, anti-harassment, anti-discrimination policies. So you could consider doing that type of training. And those are the types of things you can do to minimize liability. Of course, nothing's 100%. And even if you do all of these things, there's always a chance you could still get sued, but at least you can minimize any type of liability. So, I mean, that's basically in a nutshell what I wanted to go over, because I really wanted to open it up to any questions you may have. I mean, I could go on more. I can talk about it for several hours if you want, but I figure I would give you an opportunity to ask questions.
I have a quick question. You talked about some of the letters, emails that you could send out to staff, and you talked about policies. Are there some resources or some websites that you could direct some of the people to go where they might find a template if they don't already have these policies in place?
Well, I certainly have them, and I can provide some of those policies. Does everybody have an employee handbook? Or is there anybody here who does not have an employee handbook at their organization?
So some of our organizations are small, so we might get some that don't have it.
Okay, so the California Chamber of Commerce, I think for $500, they have an employee handbook software that can fit to your needs a little bit, and it's inexpensive, and it's a pretty good handbook. I haven't read it, but I understand it's a pretty good handbook. That's through the California Chamber of Commerce. I also draft employee handbooks, but those tend to be much longer and more expensive. But if you don't have an employee handbook, I would certainly get one. Even if you're a small organization, well, when you say small, like 5 employees, 10 employees, yeah, I mean, even at that number of employees, I think it's good to have an employee handbook. You don't need to spend a few $1,000s on a huge one, but I think if you go like to the Chamber of Commerce, you can use their program and have some type of handbook in place, because the handbook will have an anti-discrimination policy, anti-harassment, anti-retaliation policy, and I can certainly provide you some of the policies that I've drafted as well regarding those things.
Great.
Yeah.
Okay, so there is a chat in the, Patricia asked a question. Do you see that, Ron?
Let me see
So
here.
she said, according to Labor Code 2802, reimbursement for remote work employees seems to be
Yes.
mandatory. Do you see that text?
Yes, I see. I'm reading
The
it.
chat? Okay. So
Okay. Okay, so this has to do with Labor Code Section 2802. Is there a set calculation or guidance for nonprofit orgs to go by? Not specifically for nonprofit organizations. I mean, there's a whole bunch of case law on what calculation you should use, but that really comes to reimbursing for cell phone expenses. Some companies will just pay a certain proportion of the cell phone expenses if the cell phone is also used for personal reasons. So there's nothing specific to nonprofit organizations, but at the end of the day, if an employer requires an employee to use something to incur expense related to the performance of the jobs, the company, the employer has to reimburse that. Let's see, we provide most of the equipment, okay. So when it comes to cell phone usage, if someone has their own personal cell phone and they want to keep it because they have unlimited data, what employers need to do is basically figure out generally, okay, what percentage of time does an employer use a cell phone, does an employee use a cell phone for business purposes or personal purposes? So like at our firm, we provide a $50 stipend to every employee because we all have our personal phones. So that's probably reasonable. You're not expected to be exact. You just have to come up with some reasonable number that you believe would cover the business use aspects of the cell phone. Okay, let me see. Is there anything else here? Okay, yeah. So I see there was the link to the handbook. So at a minimum, get a handbook like that. Have something. And I would trust the Chamber of Commerce because they're counseled by attorneys and they do a lot of HR stuff. So I would certainly trust their handbook, at least for a smaller sized organization.
And then Lauren sent a question.
Who does?
Lauren, do you see that?
Is
what,
it? Oh, here.
What can we ask employees about COVID?
Okay. Yes, you can ask employees if they've been exposed to COVID-19 or if in fact they're infected with COVID-19. That's absolutely allowed. The only thing you have to be concerned about is if the employee has been at work and you find out that the employee has either been exposed to COVID-19 or is infected with COVID-19, you need to ask the employee, who else at the company have you been around? Because you have to go to those employees and you probably need to quarantine them and probably have them go home. But you can't tell those other employees that the employee you spoke to has COVID-19. You can't identify the name of the employee that is infected with the virus. You can just tell the other employees, we have a concern that you could have been exposed to COVID-19 and therefore we need to quarantine you or you need to go home and we'll check you after 2 weeks. So let's see, to confirm, it's mandatory we reimburse. Okay, I need to know reimburse for what exactly?
The phone. Was that for the phone?
The phone? Yeah, okay, so here's the thing. If you do not provide your own phones and your own service plan, and somebody has a personal phone, and you expect that employee to be available on the phone to perform duties or to answer work-related questions, if they're going to use the phone for some work-related purpose, then yes, you have to reimburse them a certain amount. How much? You just have to come up with a reasonable number, right? If the average cell phone is $150 and they spend 75% of their time personal and 25% work-wise, then maybe you only reimburse them 25% of their cell phone. But yes, but if you are going to require your employees to be available by phone and you do not provide the phone and service to them, you'll have to reimburse them some amount of the cell phone bill. Okay, what about for internet that they are using at home when they had it already in place? Yeah, that's a good question. So if you are requiring people to work from home and they need internet access to perform their job duties, then yes, you probably should reimburse them some amount, not the whole amount, but come up with some reasonable proportion.
And then do you see one of the questions is how should they, do you have a preference? Should it be part of their payroll or can they receive a stipend, like an expense stipend?
Yeah, I would do it as a stipend every month, separate and apart from payroll. You know, write them a check for cell phone reimbursement.
And then Amy has a question. Is there language for that reimbursement requirement that she can share with the board or an HR legal code she can refer them to? It sounds like they might be getting some resistance from their board on these reimbursable expenses.
Yeah, sounds like that. Yeah, Amy, why don't you email me and then I can look at a policy that I have about cell phone reimbursement and I can send that to you.
And then would you share that with all of us? Because I imagine there are others on this call that would like that as well.
Sure, yeah, I mean, if you send me an email that has everybody's email on it, yeah, I can share anything I send to her to the rest of the group.
Yeah, I've got 3 people that want that. So yeah, so Robin will make sure that we get that to you, Ron.
Hey, Ron, can you just forward it to me and then I will forward it to everybody on the call?
Sure. Just make sure I have your email address. Absolutely.
Okay. Yeah. Lauren has an email address.
Oh, okay.
There is another text here. We have a cell phone reimbursement now. Before COVID-19, we found an app for our staff to use to call our families that protects their personal phone numbers and looks like it is coming from their office extensions.
Okay, say that again. I'm not sure I quite
So
understand.
I'm not sure, Dawn, and Dawn, I don't think her mic is working. So I'm not sure if this is just an FYI or I'll wait until. So Dawn said to me, Dawn Reese, she said she has the name of an app for the staff to use to call the families that protects their personal phone numbers. And it looks like it's coming from the office extension. So it's just an FYI. So, okay, so we'll get that app. She'll share that and then we'll share it with the others. Because I'm sure there are other sensitive phone calls that are going on from home and people don't want their home number. So that's great to know, Dawn. Thank you.
Sure. Looks like Christy Perez has a question.
So I'm curious about when we're able to go back into the office and you listed all the things that we need to do to maintain the cleanliness and the safety. What if you still can't find a lot of those items, like enough masks and gloves and bleach type wipes?
Yeah,
I mean, I have like thermometers on order for like 2 weeks already, but what are you supposed to do when they're not all available yet?
Yeah, that's a good question. You'll just have to make a judgment call. Right now the stay in place order is still in effect, and I suspect that Governor Newsom's not going to lift it for several weeks. So between now and then, hopefully you can get more of those products. But once the stay is lifted and you're allowed to go back to work, but you don't have those items, you'll have to make a judgment call. Do you still want to send employees to work without masks, gloves, cleaning equipment, disinfectants? It's going to have to be a judgment call on that. There's no right answer, unfortunately. If you still want to have employees go back to work, you do the best you can do. If you don't have masks and gloves, then implement social distancing protocols. Maybe have people sit at least 6 feet apart. Stagger your workforce that only a few people are at work at any one time. Maybe you hire a company to come in and clean and disinfect the office, every day or every other day. So there are other steps, measures you can take to try to make the workplace as safe as possible.
Thank you.
I didn't know that, but they are suing because of the coronavirus.
I think somebody needs to mute. I think we might have some people that aren't muted. I just sent everybody a document, and my son works for a company that is donating masks to nonprofits. So feel free to click on that link and you can apply to have your organization receive free masks. There's no guarantee. I don't know what the limit is, but feel free to use it. I've shared that with a couple of you that have asked, but it's in the chat.
Oh, and also one of my firm's clients is a wireless cell phone provider. They make different wireless equipment, but they've transformed into making KN95 masks that are FDA approved and other PPE. So if you send me your information, I can hook you up with that organization. And they charge, but I think it's fairly reasonable rates for that type of equipment.
Right. Lauren, would you mind putting Ron's email in the chat just so that everybody has it handy?
Oh, sure. Yeah, I can do that.
I see Mark Lee. You have a question?
Yes, hi, thank you so much for the useful information. I was curious to know, I haven't been on CalOSHA's site in a really long time for a lot of reasons, but I was curious to know if they have recommendations for additional safety precautions or protocols that we could take to ensure a safe work environment for our employees, such as checking temperatures and other kind of tips or recommendations that we could do to ensure that safe working environment.
I believe they do, and OSHA has also, and the CDC. I have a lot of that information. Again, I can provide you, I've created a whole Dropbox database at our firm with all these different brochures and forms and guidelines and case law and statutes. So I have the guidelines from the CDC and from OSHA, and I can send those to everybody as well.
I see that Amy asked another question here. Do we need to reimburse employees if they are asked to download an app on their phone, if they would be using it occasionally moving forward?
Okay, are those apps, do they cost anything or are they free?
I imagine they're costing if they need to reimburse them. So there must
Yeah,
be
that's
some
what I
apps,
assumed.
like she said, group. So if you are insisting, I would imagine if you're insisting that they use these moving forward, then you have to reimburse them.
Correct. If you're requiring that employees use these apps on their phone and the apps cost money, then yes, you would need to reimburse the employees for the cost of the apps.
It sounds like what you're saying though is that they're having to use their data to continuously use it. Then are you paying for their data? Is that right, Amy?
Sounds like, yeah, she said the app is free. Yes, but they must use it continuously.
Oh, okay. And so they're, just so I'm clear, they're using the phone for work-related purposes. So that goes back to the previous answer before. You got to come up with an amount that'll reasonably cover the cost of the phone related to their use of it for work. Mm-hmm. And again, of course, not going to say, oh, you mistakenly came up with a 25% time and it really should have been 33%. You know, the court is not going to scrutinize it at that level. As long as you come up with a fair and reasonable estimate of how much they're using their personal phone for business use, then you have to provide them with a stipend. Like, for example, at our firm, we give out a $50 stipend to every employee. And that's what a lot of companies do. They just come up with a number that they think is reasonable and fair, and they give it to them every month.
And in the case of Robin and I used to get $30 because, but now that I'm required and it's, you know, everything I get 50.
Right, yeah.
Because it's more apt. Now, do we have to go back, once we get back into the office, should it be scaled back? And can you ask them to scale it back?
Well, it depends if they're not using the phone as much for work-related purposes, yeah, you could scale it back. I mean, I don't know if it's worth it to go through that whole thing over, I mean, if it's $30 and you're thinking about reducing it to 15 or 20, I don't know if that makes a big difference. It could, maybe it could for a nonprofit, but yes, you'd have to evaluate and see if they're using the phone less. So.
Any other questions? If you don't want to ask on the screen, you can type it in the chat. I don't see anything else. Ron, what else do you have for us?
Well, I mean, there's a whole bunch of other stuff we could talk about. Let me think. Let me take a look and see.
I have a question.
Yes.
Sorry, hold on. I'm going to try to adjust my volume so we're not echoing. What about employers that are doing temperature checks? Can you talk about how the recording of that, et cetera, is handled, or how that should be handled? Record keeping around temperature?
Yeah, that's a good question. So that is health information, and so it should definitely be kept private and confidential. It should not be in the personnel file of the employee. It should be maintained in a separate protected database. And then there's another issue is for the individuals who are actually taking the temperature, you have to provide them with protective equipment. They need a mask, gloves, sanitizing wipes, so that they're not somehow infected if they're taking the temperature of an employee who maybe is infected. But definitely you have to maintain the privacy of that information because it is, you know, it's HIPAA protected information. But look, if an employee comes in and you do you take the temperature and it's a regular temperature, you're probably not going to record it anywhere anyway. The only time that you might record it is if the temperature is high. And then at that point, you have to decide, are you going to send the employee home because you're concerned that the employee may have COVID-19, because a fever is one of the signs of COVID-19.
Ron, I have a question. What happens if you have an employee that says, I can't come back to work because my kids don't have school to go to, and I have to stay home to watch my children, and they don't have a work from home job?
Right. So if the work is available for them, but they just can't come to work because they have to care for a child and they can't telework either. The job is such that they can't telework. Well, in that situation, they would be entitled to get what's called the emergency paid family leave under the FFCRA, because the FFCRA applies to employers with fewer than 500 employees. And in a situation where there is work available, but the individual cannot work at the office or at home because he or she has a child under 18 whose school is closed and who has no daycare. And so in that situation, you have to provide 12 weeks of paid leave at 2/3 their normal hourly rate. The first 10 days are unpaid, although you can use what's called emergency paid sick leave to cover those 10 days. And the remaining 10 weeks, you'd have to pay at 2/3 of the regular hourly rate or salary.
So the employer is paying this person 2/3, or it's coming through FMLA?
So the employer is paying the 2/3 of the salary for the whole 12 weeks. Now the employer can get a tax credit. They have to keep documentation showing that they've paid this to the employee, and then for this tax year, they can apply to get a credit for the full amount that they've paid. I'm not sure how it works, because I'm not, an accountant or a tax lawyer, but you should definitely, if you're going to do that, talk with your CPA to make sure you have everything you need in order to get that tax credit.
Great. Christy has a question.
Yes.
So hearing all this, I was going to hire a new employee right before this hit, but this is making me think maybe this isn't the right time to hire more people, because it's just so much more potential liability or paying for, like that kind of leave for 12 weeks when they're not actually working anyways or something. So what's like your professional opinion on that? Should we just kind of hold off on employees if they're not like complete, like we can make it for a while without them?
Right. So the paid family leave portion only applies to a situation where an employee can't work because a child under 18 is home and there's no daycare. So that's a limited situation. And there's also an exception for that for if you have under 50 employees, there could be an exception from that. But you'd have to kind of document why you're not providing that leave. But going to your question, look, if you need to hire somebody in order to run your nonprofit organization, if it's critical that you hire somebody, I wouldn't let this prevent you from doing so. You have to make a practical business decision here. Hiring employees is always a bit risky, but employees are your biggest asset and biggest liability. And if you need an employee in order to run your organization, if it's critical, I wouldn't not hire the employee.
But if it's not critical, it was just like on our next step of like what we want to do, but we can maintain the way we are for a while longer.
Yeah, I just wouldn't let the risk of what's happening now cloud your judgment. If you need to hire somebody and there's a business decision, a good business reason for it, I would do it.
Okay.
Yeah.
Ron, do you see Adolfo has a comment? EFMLA only applies to employees that have worked for a minimum of 30
Yeah, that's
days.
correct.
Is that correct?
Well, yeah, that's correct too.
Okay, other questions?
Well, this seems like a stupid question, but
Nah.
by all intents purposes, nonprofits don't pay taxes. So how would they be getting a tax break?
That is a good question. I don't know. Yeah, I don't know how that would apply, but but a lot of nonprofits are under 50 employees. So they would probably fall under that exception where they can show that it would be an undue burden essentially on the organization to have to pay 12 weeks of 2/3 of the salary of an employee. So I would think that most of you probably would fall under that exception. But the exception is something that you have to employ, meaning someone comes to you and says, look, I can't work anymore. I can't telework. I need to take care of my son because my son's school is closed. You would have to say, well, there is this exception. We can't do it because we're under 50 employees and it would be an undue burden on us to do so. And yes, I saw Don sent a chat about there's a cap. There is a certain cap on the total amount that you have to pay per employee. But again, that amount could still be too much for a small organization. So if you're under 50 employees, which most of you are, if this situation comes up, you may want to consider using that exception.
Well, Allison had a good point. Okay, so it's in payroll taxes. Okay.
Yes, that's right. So yeah, you got to speak with your accountant. So yes, it does relate to the payroll taxes. So you do pay a portion of payroll taxes. So you would get a credit against that.
Okay.
Now, I don't know if there's some other exception for nonprofits, if there's something in the IRS code or this law that deals with nonprofits, but definitely talk to your accountant in order to get that tax credit.
And they can't just go on regular disability.
You mean under the California Employment Development Department, under the state disability? No, they could. They could potentially. Well, it depends what the reason is. If it's to care for a child, no. But if they are potentially have COVID-19 or if they're infected with COVID-19 and they're not, and that prevents them from doing their job, then yes, they could potentially get state disability. Even unemployment insurance now has been expanded. So up until now, unemployment insurance only apply to employees, but now it's been expanded in California to include independent contractors, gig workers, self-employed, that if they no longer have work, they can get unemployment insurance.
Pam has a question here, Ron. Do you see that?
Let me see. If we have partially. So, okay, so when it comes to exempt employees and partially furloughing them, if an exempt employee works any part of a week, you have to pay them for the whole week. So the best approach is if you're going to furlough full-time exempt employees, do it on a week-by-week basis, because any week that they work, any day that they work in a week, you have to pay them their salary. So furlough them for like 2, 3, 4 weeks, nothing less than a week. Also, if you reduce the salary of an exempt employee that goes under the minimum salary threshold, then they will no longer be exempt. Now, what I have told clients is, if you have an exempt employee that pays a salary and you want that employee to work for a certain period of time during each week, but you don't want to pay the full salary, right? If the employee only works 10 hours a week, you don't want to pay for the full week. You can convert them to non-exempt. There's nothing that prevents you from taking an exempt employee to say, look, either we have to let you go or we can convert you to non-exempt and we'll pay you by the hour. We can only afford 20 hours per week. We can't afford to pay you your full salary. So in that case, they would be non-exempt, but you'll need to comply with all the wage and hour laws. They'll have to clock in and out. They get meal breaks. They have to get all the other requirements of the wage and hour laws. So if you're going to make them non-exempt, you have to understand that they're going to have to clock in and out, get meal breaks, rest breaks, etc. But that could be an option for some nonprofits where they have a salaried exempt employee. They need that employee to work a day or two a week, but they can't afford the whole week's salary. So maybe you convert them to non-exempt as long as the employee agrees. But sometimes it's a choice between either being furloughed completely or laid off or being converted to non-exempt and getting paid hourly.
And then can they apply for unemployment for reduced hours?
Correct. Exactly. You can file for unemployment insurance for the reduced hours. Yep. Yep. Let me see here.
So Ron, when you and I first talked, you had talked about helping the nonprofits, you know, that you were offering your services. So can you talk a little bit about that?
Sure. So my firm, as part of what we call this COVID-19 task force, we're offering an hour of pro bono legal services, not just to nonprofits, but for profits as well. If you have any questions or concerns relating to COVID-19 and how it impacts your business, or the labor and employment issues revolving around COVID-19, we'll give an hour of free advice. And between you and me, for nonprofits, I'll give you more time too. I've provided pro bono advice to Habitat for Humanity of Orange County, for American Family Housing, for what was the other one, Robin? Homemade. So yeah, I'm happy to give some pro bono advice for nonprofits. Absolutely.
So helpful, Ron. Thank you so much. Any other questions? Christy.
I'll take the time if nobody else is using it. And this doesn't actually affect me, but I've heard of other businesses having this happen. And so maybe other people on the call. But people that are taking unemployment insurance now are getting that extra $600. And then when people are asking them to return to work, they're making more money on unemployment. So what's your advice to employers on that and how to handle that?
Well, the question is, has any stay-at-home order been lifted? I mean, if there's still the stay-at-home order and the employer is not a critical, essential business, then you can't really force people to come back to work. I mean, you could lay them off. I mean, they would still get unemployment insurance, but...
Well, the one that I know of, like, he works at a golf course and they did reopen. And so they called their employees back, but they're like not wanting to go back because they make more on unemployment.
Is this a golf course in California?
Yeah, it's right down the street from me.
Huh. I'm not sure that would be considered an essential business. But look, once businesses can reopen, and there's no order in place saying that they can't reopen, if an employee refuses to come to work because they want to get more money through unemployment insurance, I would say either you come back to work or we're firing you. But I would be careful about forcing employees to come back to work here in California when we still have Governor Newsom's stay-at-home order in place, as well as most counties still have a stay-at-home order in place. I know that different counties are now loosening restrictions, but I can tell you in Orange County, the Board of Supervisors has said, even if in Orange County we loosen our stay-at-home order, you should still comply with the California stay-at-home order. So I would be more cautious and be more conservative here. If the stay-at-home order is in place and you're not an essential business, I would comply with the stay-at-home order and not force employees to come back to work. Because the worst thing you want to do is, if you're a non-essential business, is force your employees to come back to work and one of them gets sick, right? Or one of them resigns because he or she doesn't want to come back to work and you open yourself up to a wrongful termination lawsuit. I would just be more cautious until the stay-at-home order in California is lifted.
So even if, like Orange County, I thought what Newsom was saying is they were going to handle it regionally and let localities kind of dictate, but under the same guise of, the phases. So if Orange County says, okay, you can come back into office buildings now, that's not going to hold?
Well, it depends what the California order says. And if Governor Newsom comes out and says, look, you can follow county orders, then fine, follow the county order. This is so fluid, it's changing day to day. I know that the governor put out a 4-step process for reopening California. So what I would say is, are you all in Orange County or in?
Yeah. Christy is not. Christy's in the Inland Empire.
Inland Empire. And I believe the Inland Empires, the stay-at-home order is lapsing pretty soon, I believe, for Riverside County and San Bernardino County. But what I would say is I would wait to see the county order when that's rescinded or loosened, and then see what Governor Newsom and the state of California say. And if they say that you can follow your local regional stay-at-home order or the rescinding of it, then follow the local order. But if Governor Newsom says that the California stay-at-home order is still in place and we expect you to comply with that one, then you comply with that one. So take it one step at a time. See what the county says, Orange County says, and then see what the state of California's response is, and then decide what to do.
Great. Okay, well, it's 1:57, and I want to respect your time and everybody else's time. Robin will send, once she gets some information and links from Ron, she will attach it and she'll send you the link to this call. And the chat will be saved in there, but right now, if you wanted to save the chat with any of the links, you just go to the bottom of your chat where there are 3 dots and just click save chat. And then that saves it so that you can get the information whenever you want it until Robin sends it out. But first of all, Lauren, thank you for coming forward and volunteering your husband. And Ron, thank you for this hour. So helpful. Again, we've had 2 employment attorneys kind of at the beginning of the crisis, and I feel like our needs now are different than they were 4 weeks ago. So this is helpful. We might reach out to you in another month and see if you would be willing to do another one, because I imagine once we've reopened, we're going to have a whole slew of questions. So again, you're a friend of the network and we're just forever grateful. So thank you.
Happy to help. Thank you.
And thank you everybody for joining, and Robin will make sure she gets all the information to you. Have a great day and be safe.